about a topic. Today is about a journey. When we started this webinar journey, there was no master plan to reach this milestone of 250. The intent was simple: to create a shape where professionals could understand changes, ask difficult questions, and think beyond compliances. To create a space where complexity was simplified, where professionals could think clearly in uncertain time, and where knowledge could be shared responsibly. Over the year, laws evolved, regulation changed, market evolved, and technology transferred the way we work. But one thing remained constant: the need for clarity, ethics, and informed judgment. These webinar was never meant to create noise. They were meant to create understanding, never to influence, but to educate, never to react, but to prepare. The journey became possible because of trust of our speakers and regulator, the discipline of our CP team, and the commitment of the professional who choose learning over shortcuts. As we cross this milestone, I see a next phase not in terms of numbers, but in terms of impact. Deeper conversations, responsibility through leadership, and a stronger institution. Today, as we mark the 250th webinar, and this is the 250th session also, we do so with humility, acknowledge the institution are built not by event, but by consistent and discipline over time. Thank you for walking with us for this journey. The journey continue with humility, responsibility, and purpose. Now I will request Shivam that 2 minutes video of this 250 webinar journey can share.
That this is a pandemic.
They say consistency is the hallmark of expertise. But true consistency is tested in uncertainty. When the world paused, we pressed forward, turning disruption into direction. It began with one webinar, one Friday, one purpose: to bridge the gap between knowledge and action. From the Companies Act to SME IPOs, from FEMA to valuation, from governance basics to regulatory foresight. Week after week, complexity was decoded. 249 Fridays, over 1,000 hours of expert-led knowledge. More than 400+ thought leaders, and a growing community of over 175,000 professionals, regulators, practitioners, industry leaders. Every session built on experience, every discussion driven by relevance, over 6,500 participant queries addressed, actionable insights delivered, recommendations shared with key regulatory bodies, from SEBI to MCA, from policy clarity to governance reform. And now, we reached a milestone. Our 250th webinar. This isn't just our journey. It belongs to every professional who logged in, questioned, learned, and applied. Join us for our 250th edition, as corporate professionals continues to shape the future of governance.
So thank you, everyone. Now I just want to share our journey, and I want to just give a one presentation of how the journey has taken place, what we have done, and what is our plan for future, and what we have achieved. So, sir, this 250th journey knowledge webinar, a journey of learning, integrity, and institutional thinking. Today is not about a topic, it is about a journey which we have started in 2020 and 20th April. It has came when the COVID uncertainty was there, but our purpose was really clear: the complexity, how we can reduce. So purpose came before the number which we are talking. Next. Now, the journey so far, we started on 28 April 2020. Then we have a 50th 50th webinar, then we have a 100th webinar, and then we have a 150 and now 250. This vision of beyond 5 years impact was knowledge and professionals, bridge the regulator and policymaker and the corporate world. That was the theme on which we have started. Next. Knowledge as a discipline, that was our main focus. So we have done this weekly conversation without any fail, whatever it is, except holidays which are there. Steady participation, professional return week after week, because today we have 1,75,000 registration on different topics. Continuity during the uncertainty, whatever it is, it will be. So consistency build credibility, that is the main theme on which we have worked. Next. The consistency is with discipline, define the journey. 400 speakers has come, 1,75,000 registration was there, 6,500 queries we have received on different topics. The 250 in perspective, we see the journey speak itself, because we have 250 webinar delivered, 1,000 learning hours we have done, and many more will come in future. Next. It is not only about the volume of topic, but responsibility of interpretation. We have topics that shaped conversation: 109 securities law, 60 company law, taxation 8, corporate governance, labor law, insolvency, deals, social issues like POSH, succession planning, valuation and regulatory update on continuously on different topic of company law, security law, insolvency law. So this is a 249 webinars journey has taken place. What never changed the CP DNA? Knowledge with purpose. Every session designed to add meaningful value. Understand over opinion. We have done the facts analysis, not personal viewpoint. Ethics over shortcut, the right way, not the easy way. Institution over individual. Building system that almost outline any single person and any single issues. Then come to the impact of our webinar. The impact is timely dissemination of information, resolution of industry query, structured deliberation on consultative paper and policy feedback, because we were thinking on proactive approach, not the reactive. Actionable recommendation to government, and it has impacted a lot. Promotion of a strong governance, ethical engagement between regulator, professional and industry. That was the target, and knowledge depository we have created through the questionnaire and FAQs. Now from rules to reasoning. So we started compliance following rules, context, understanding why. Reactive, responding to issue in place of proactive thinking, what is ahead. Rules, what must be done. Principle, what should guide us. So journey moved from surface level compliance to deep understanding of context and principles. Our learning ecosystem was simple. Professional keep returning week after week. Questions matter more than answer. The community grow, but through genuine value and mutual respect. The strength of a platform is not who speaks, but who listens. That is important. The ecosystem thrived because participation came to learn, not to be sold. To be that some marketing is happening. They came to question, not to be told. They came to grow, not to be impressed. Then voice that added depth. Our speaker, our people from different field, they were the independent expert, regulatory perspective they have given practical experience. So platform over personality, that was the guiding principle for us. Now what is we are looking ahead? We want to invest in technology, knowledge technology. We want to broaden the audience reach. We want to expand knowledge format. We want to foster collaboration to have more program on these types. The next 250 from awareness to impact. So this 250 was awareness. Now we want to create an impact on this. So deeper engagement, better documentation and institutional strength we want to create. So this 250 knowledge conversation completed, many more to shape the future. Now, these are the outcome of our consultative disclosure and representation, we have worked closely with SEBI. So SEBI settlement scheme, insider trading, PIT, regulation 30, the price discovery of listed companies, which are investment holding company, ease of doing business of REIT and InvIT, harmonize of ICDR, UPSI, review of SME segment, ICDR and LODR. This we have worked with SEBI and we gave us lots of suggestions. SEBI released FAQ and PIT on the basis of 29th April. We have a program and then we have done this. Then we have done with insolvency, pre-pack insolvency program we have done and we have given suggestions on the basis of this webinar. And then we have a various program on MCA, on CSR, MCA 21, version 3, reforms in company law, limited liability and company law committee report. On various things we have given suggestions. Now these are then we have done a webinar on M&A of PSU companies and they became out a handbook also on this. Now friend, continuity, not completion. That is the theme. Learning does not conclude with milestone that we have reached to 250. It is not the aim. It continues through responsibility, discipline and reflection. Institutions are strengthened not by louder conversation, but by consistent, thoughtful ones. That continuity carries into today's discussion and the 250 webinars which we have done. That is the background which we now the continuity is that today we have our session on Securities Market Code 2025. And today we are not with celebration, but with commitment. As you would have noticed, this journey was about how knowledge platform mature through consistency, integrity, and clear boundaries. That very thinking guides today's discussion as well. Our 250th webinar focus on Securities Market Code, a subject where interpretation, institutional clarity, and proactive dialogue are especially important. The session is not just to understand the framework, but also collectively reflecting proactive approach, because this is in Parliament Standing Committee. So if we can give suggestions today, they can consider and they can include. The share perspective and responsibility contribute suggestions that may help strengthen the ecosystem. With that, let me now move today's topic. So today's topic is Security Market Code. Now we will tell it SMC 2025. It has introduced in Parliament and then it has referred to the Standing Committee, which is a combination of now SCRA, SEBI and Depositories Act. And the purpose is simplify compliance, strengthening market integrity and enhance investor protection. And the most important thing is modernize regulatory oversight in line with evolving market realities. This webinar is designed to facilitate an informed discussion on proposed provision of the bill, the policy intent behind the introduction, the potential implication for India's capital market ecosystem. And in this session, we'll critically examine the structural changes under the code, including proposed regulatory architect, expanded scope of securities, enforcement mechanism, and institutional safeguard. As the bill is in deliberating state, the Parliament Standing Committee, the webinar will also serve as a platform to reflect on practical challenges, transitional issue, and the area that may require further refinement during the legislative purpose. It aims to contribute meaningful to stakeholders' understanding and discourse ahead of the court's possible enactment. We look forward to an insightful discussion and thoughtful perspective from our speakers and participants. And we have shared one the survey also about this code, and the survey's result we will declare at the end of the program. And today, that's why we have invited the people from the security market, those who have worked in the SEBI and regulatory area. I welcome first our chief guest, Mr. M. Damodaran, founder and chairperson, Excellence Enabler, and former chairman of SEBI. I welcome you, sir, for this program, and your deliberation and knowledge and your deep understanding of governance will helpful to shape this law in a new dimension. Then we have our guest of honor, Mr. M.S. Sahu, founder Dr. Sahu Regulatory Chamber, former chairperson of Insolvency Board, and former full-time member of SEBI. I welcome Mr. Sahu. He is par excellence academician and knowledgeable of the capital market, and his life has continuously he has devoted time on academic as well as practical exposure. I welcome Sahu sir for this program. Then other panelist of the today's webinar, Mr. J.N. Gupta, founder, Stakeholders Empowerment Service and former Executive Director of SEBI. I welcome Gupta sir. Then we have Mr. Naginder Parak, former Executive Director SEBI. Then I welcome Naginder sir, and I know your expertise on option future market depth knowledge will definitely helpful for today's discussion on the instruments. Then we have Mr. P.K. Nagpal, who is also former Executive Director SEBI, and he has worked more than 30 years in SEBI. Then we have Mr. R.S. Luna, Managing Partner, Alliance Law and former Executive Director SEBI. He was a legal head, and his understanding of this particular new code will definitely helpful to all of us. I welcome Luna sir. Then we have Mr. V.S. Sundaresan, former Executive Director SEBI. His expertise, knowledge, and recently he has completed his superannuation will definitely helpful to understand, because he is a person in the entire lot who has recently left SEBI. I welcome Sundaresan sir. Then we have Mr. P.K. Vindalesh, former Chief General Manager of SEBI. He's economist, in my opinion. He's a chartered accountant, but economics understand the capital market very differently and very deeply. I welcome Vindalesh sir. Then we have Mr. Sharad Sharma, former Chief General Manager of SEBI, and Sharad Sharma has worked in CCI, in SFIU, and SEBI. So his knowledge and expertise will definitely helpful for today's program. Then we have Mr. Ravi Prakash, Associate Partner, Securities Law and Corporate Litigation, Corporate Professional. And the all speakers, their advantage is they have worked in these areas, and today's deliberation, they can share their thought on this. Now, I will request our chief guest, Mr. Damodaran sir, that we have come out our book Compendium of the Securities Market Code 2025, and I will request you, please release this. Damodaran sir. Okay, Shivam. So this is very unique book which we have come out. I will request Shivam just give brief so everybody will understand and it will be useful. And the book we have already printed, but whatever suggestion will come today, we will incorporate and send it to all our speakers, and then their point will include in this. Then after that, we can send it to the Parliament Committee. Over to you, Shivam.
Thank you, sir. Thank you, Chief Guest, sir, for releasing this book. So this book is divided into 3 divisions. Division 1 includes insights on the Securities Market Code 2025, including explains why the Securities Market Code 2025 was introduced, why India needs a Securities Market Code, comparison of old acts versus new code, key definitions under the code, what is completely new in the code, regulatory architecture under the code, powers of SEBI under the code, inspection, investigation, adjudication, and appeals, interim orders, when and how issues issued under the code, penalty and enforcement under the code, what changes for investors, what changes for companies and intermediaries under the code, self-regulatory organizations, SROs under the code, enforcement and compliance framework. Apart from these transitional provisions and FAQs on the code. And in division 2, there is issues, interpretational challenges and case laws which has been resolved and unresolved under this code, including issues likely to continue even after this code implementation, new issues may be introduced by this board. And in Division 3, we will incorporate suggestion, comments, and recommendation on this new Securities Market Code, including legislative drafting suggestions, regulatory safeguards and due process, investor protection enhancements, ease of doing business, and market development related suggestions, transitional and implementation recommendations, and suggested areas for parliamentary considerations.
Thank you very much, Shivam. Thank you for giving this. So this book, we will send it to all participants and we will upload on the social media platform also. So it can be useful for everyone can give. Now, it's a time to begin our webinar and I will request our chief guest, Mr. Damodaran sir, to say about this particular law, how we can improve this and how we can give suggestions so the law will become better and we suggest them proactively, so we should not react later on. Maybe they may not accept our all suggestion, but we have to bring it to the knowledge of these people. Over to you, Damodaran sir.
Thank you, Pavan, for having me here in your midst. It's been a phenomenal journey. 250 not out. Many others who've started out on similar journeys, not identical journeys, have been dismissed along the way or have retired hurt, but certainly have got out and their innings has come to an end. But at 250, you can raise your bat and hope to continue this innings for another 250 more. Your weekly webinars are productive. They are very professionally run, and certainly they distribute a whole lot of information, of knowledge, and of wisdom to all those who participate. And those that miss out would certainly get to hear about it, read about it after that. I must also thank you for bringing here to this event a large number of my former colleagues in SEBI, my contemporaries. I don't want to take names, their names are all up there, but I've had the privilege of working with all of them during the 3 years that I spent in SEBI. Phenomenal persons, phenomenal human beings. They added great value at a critical time in the organization's history, and I'm delighted to see that they are here in this conversation. I'm particularly delighted to see that Dr. Sahu is a part of this conversation, even though he did mention briefly that he was moving from one program to another, but being nimble on his feet, I'm sure he can do 2 programs comfortably. It should not be a problem for him. Dr. Sahu has written on the code and introduced a large number of very insightful suggestions which will help those that are going to finalize the law and to enact the law, to consider what is right, what is missing, what ought to be strengthened, and what ought to be omitted. And therefore, I think it's good to see him here, but not to take away from the fact that all the other former SEBI officials on this, I'm sure, have done the homework and come here based on their experience. It makes life a lot easier for me because I don't have to touch on any of the specifics. With so many experienced batsmen to follow me in the batting order, I can afford to swing my bat a bit, and if I don't connect with the ball, it doesn't matter. There will be enough people going forward to score the runs that you need to score on this particular innings. Having stated that, let me firstly compliment the Ministry of Finance. I know it took 5 years after the minister made the statement in her budget speech regarding bringing together 4 enactments, not 3, including the Government Securities Code. It took 5 years, a long consultative procedure. Maybe some steam was lost along the way. There were other preoccupations, other priorities, and therefore maybe this did not proceed at the pace at which we expected it would. But that said, I think the first good point is that they've only taken 3 enactments and brought them together, and they have left the Government Securities Act, which clearly doesn't belong to this holy trinity that has come together or has been put together now. That, I think, is a positive. That said, I want to make a few points, not too many given limitations of time, but let me start at the beginning. In the Berubari case in 1960, the Supreme Court said that the preamble to the Constitution is the key to the minds of the makers of the Constitution. Similarly, for all enactments, the preamble is the key to the minds of those that enact the law. I am a little disappointed at the preamble to the SMC, because all that it says is that it is putting together 3 enactments. That is not the larger objective. That's an instrumentality. The larger objective should have been derived from that excellent preamble to the SEBI Act of 1992. I've looked at a lot of preambles in the securities market space and elsewhere, and I think the preamble to the SEBI Act of 1992 is an excellent example of what a preamble ought to be. But to tuck away that in clause 11 of the clause 11.1 and use nearly the same language, which is subject to the provisions of the code, the board shall protect the interests of the investors in securities and promote the development of and regulate the security. I don't see why this cannot in some manner be restored to the preamble of the SMC 2020. We touch on a few other points where I have perhaps a difference of opinion. Now, whenever any enactment is drafted, clearly it is only substantive issues that find place in the law, in the statute, and procedural matters, matters of detail, matters of implementation are then prescribed in the rules and regulations. After reading this, my worry is that there could be quite a few substantive issues that get addressed. And this has been a failing of the last several years, that those that draft the law manage to put in matters of substance in the rules and regulations and not in the act. This is a failing. It's a violation of the principle of delegated legislation. And I'm sure when this goes to the Committee on Subordinate Legislation, that is the lens through which I would be looking at this. The related point is that whatever is defined, subsidiary instructions, namely circulars, master circulars, guidelines, and such other instruments are under clause 148 expected to be laid before each House of Parliament. To my mind, this is clearly excessive. It's not necessary for guidelines and circulars to be laid before Parliament. Then, therefore, my suspicion whether substantive issues will find their way into circulars and guidelines, which is the wrong way to approach legislation on a complex subject. Then I get to the composition of the board. It says that the board size shall be increased to 15 members, including 6 members who are independent of SEBI. Now, when you look at a board size of 15 members, the first question you need to ask yourself is this an unwieldy composition of the board? No matter what the complexities are which the organization seeks to address, no matter what the expanse is, no matter what the scope is, A 15-member board, to my mind, could be excessive. And I think a number between what exists now and 15 should be settled on. When I did some calculations, I thought an 11-member board would serve the new SEBI. And I say the new SEBI because of the three enactments. SEBI 2.0 would serve right. The second is that you have to find enough members who are experts in the securities markets. Now, it's useful to even at this stage look at how possible conflicts of interest, potential conflicts as well as existing conflicts will be addressed when you source people from the market, because if these are active people, clearly they are not sitting quiet. They must be busy in the markets. They must be discharging some roles related to the market. And therefore, this is a concern which I think we should look at. Clause 9, subclause 1 talks about the appointment of such other officers or employees as the board considers necessary. Regulatory organizations must necessarily have a large number of lawyers and a large number of accountants. That's not the way SEBI was initially staffed. There have been some attempts to address this, but to my mind, not adequate. Because if you look at regulatory organizations worldwide, especially in the securities market space, you'll discover that the principal target group for any regulatory organization when it comes to staffing is lawyers and accountants, because both these are critical to the functions that are being organized. Therefore, not just appoint officers, increase the size of the organization, expand it, but look at right contenting the organization. Very often in right sizing the organization, we forget to right content the organization. So that's an issue, I think, which needs to be looked at clearly. The next is clause 11, subclause 2Q, vests in the board the powers to lay down principles for the implementation of the code. Now, that's all it says. It vests in the board the powers to lay down. Why not take a leaf from the SEBI Act and lay down the principles in the enactment itself? Why leave it to the board to lay down the principles? Principles don't change overnight. They are there for a long time. And therefore, it would have been ideal if, as in the SEBI Act of 1992, the principles had been enumerated in some manner rather than a provision which says that the board shall have the powers to lay down the principles. Then there is one provision which is very interesting, and I hope this will be implemented imaginatively. If you look at clause 11.3, it says the board shall review its performance and functioning, including the proportionality and effectiveness of the regulations made in this behalf. We are talking about two things here. We are merging two things. One is the performance and functioning of the board. The second is the proportionality and effectiveness of the regulations. What you need to do for the second matter is to have a proper regulatory impact assessment. And if you actually have that, you don't need to merge that with a provision which is to review the performance and functioning of the board. This is a very important provision. Most regulatory organizations worldwide do not do this. They try to avoid this. But when you are reviewing the activities of everybody else, it's useful to turn the light on you, see whether you are doing what you set out to do and whether there are any improvements that can be undertaken. There are timelines prescribed for investigation. It's useful to keep our fingers crossed and see that those timelines are fulfilled, because given the legal expertise that exists in our country, there will be several ways found to go past the timelines that have been laid down. Then comes the ombudsman, and I have serious reservations on this. Clause 73 says the board may designate one or more of its officers as ombudsperson to receive and redress grievances of investors. I was happy to see the word ombudsperson because some 30 years ago, when I was the Ministry of Information Broadcasting, 35 years ago, I introduced the word camera person for the first time instead of cameraman, and there was a lot of resistance. But I'm happy to see whenever the word person is used that finally we are making gender neutral recommendations and observations. But that said, having one or more of its officers, the Ombudsman institution itself is one where I draw comfort from the fact that there is some independence, some neutrality, some impartiality, rather than somebody wearing the hat of an official in the morning and looking at my matter as an ombudsman in the afternoon. I don't get great confidence. In any case, SEBI has several mechanisms to address investor grievance redressals, and if there are shortcomings, they should be tweaked rather than create yet another obstacle. Now I am coming to something which I have talked about for a long time, which is there is an annual report to be given to the central government. An annual report is a post-mortem exercise. The year is over. What you're doing is a post-mortem. I would like to see, in order to respect the principles of accountability to the legislature, that the SEBI chairperson and the SEBI whole-time members appear twice a year before an appropriate committee of Parliament to explain what happened in the previous 6 months and to indicate what is proposed to be done in the next 6 months, so that Parliament is able to understand and in some sense endorse what the regulator is doing, rather than give an annual report which translates to a few words and numbers and does not really serve a purpose, because how can you go back on what you've done? The year is over, and I think that is something we need to look at. Now, there is one provision which is there in the RBI Act, which is in the SEBI Act, and which is the proposed code, which is the power of the government to give directions to the board on matters of policy. This power, mercifully, has not been exercised. There were some indications that this would be exercised, because the exercise of this power, even when we say it is for policy matters, is going to, in some sense, impact the functional autonomy of the organization. Please note, I am not using the word independence. No regulator is independent. You don't carve out a territory and fly a flag and say I'm independent. But you're functionally autonomous. And that should not be impacted by the power, even though it's theoretical and hasn't been used, to give directions in matters of policy. And who determines matters of policy? Matters of policy are determined by the central government. It used to be said in the olden times that most people would say, I take all the major decisions in this house and my wife decides what is major. Are we getting to that kind of a situation where you do what you think is right and somebody says, sorry, there's a policy element and I will give you a direction? This is something which we need to revisit, in my opinion. A couple of others and then I am done. The Depositories Act is one of the three acts which have been put together in this. I think the Depositories Act of 1993 should never have existed. There was no need for a separate enactment for the depositories, and there was some kind of, for want of a better word, let me say, an agenda which brought this act into being. It was not necessary at all. No other MIIs have separate enactments and this could have been a part of the SEBI Act appropriately amended. It is good that that has been taken care of. So broadly, these are some of the issues that I thought I should raise. It's like a curate's egg. It's good in parts, it's bad in parts, but I think the fact that it has gone to a committee to look at it, and that committee will be informed by the suggestions that people in this conversation, through you, Pawan, will make available to the committee, I think is going to enrich the process of lawmaking and give us a law which addresses all concerns, all requirements, but does not either overprescribe or leave some of the unnecessary remnants of the earlier enactments. Thank you very much for giving me this opportunity. And as I said at the beginning, I'm borrowing your words for making this an alumni meet of SEBI and getting enough SEBI people on this. It's good to see so many familiar faces after years, but I'm sure that I will now switch off, listen to them, and see what I can take away in regard to the code. Thank you very much and wish you a long, undefeated innings. Carry the bat for the next 250 weeks.
Thank you. Thank you very much, sir, for your kind words. And the wisdom is reflecting in your discussion, sir. The point which you have mentioned, it really very, very impactful. And I don't think that any other professional people can do this, because I'm getting all suggestions from the professional in the shape of document in the article. But these things which will come today from the side of SEBI ex officials, that I think it will be unparalleled. And you have rightly pointing out, sir, the point which is really in future, maybe the pain point, maybe a problematic, and maybe if something is happening, it is better, it's squared today. Thank you very much, sir, for your kind words. And now I will request Ravi, because all other our speakers, they are aware of this, but I will request Ravi to quickly glance through the changes, the major point of this particular code, so the discussion can be more effectively on the basis of that how we can take out certain points. Over to you, Ravi. Quickly, you have to complete.
Thank you so much, sir. Very insightful discourse by Damodaran sir. I would like to begin with recalling a observation given by Supreme Court in 2016 when they were deciding one of the appeals taken to Supreme Court by SEBI. The matter was SEBI versus Kishore R. Ajmera and Justice Gogoi, who later on became the Chief Justice of India. He remarked, "We would like to record our views on a somewhat unclear, if not a confused picture that emanates from parallel provisions contained in the Act," they were referring to SEBI Act, "and the regulations framed thereunder." They further observed that these were leading to myriad provisions dealing with the same situation. And then they said that a comprehensive legislation can bring about more clarity and certainty on the norms governing the security and capital market. Therefore, would best serve the interest of strengthening and securing the capital market. So this is something that we heard almost a decade before. The Securities Market Code has been introduced from the Supreme Court in one of the matters which was taken to the court for adjudication. Now, nearly a decade later, the code is there, it's tabled in Parliament, being pending before the standing committee. I'll just take all the participants through the code, the bird's eye view of it. So what it essentially does is the consolidation of three statutes, which Damodaran sir said the Holy Trinity, which is the Securities Contracts Regulation Act 1956, commonly known as SCRA, SEBI Act, of course, and the Depositories Act 1996. These statutes, as I just read from the observation of Supreme Court, they operated in parallel, although they were part of an integrated design. So the new code aims at consolidating them. Next slide. What SCRA dealt with? It prescribed for regulation of securities contract and trading, of stock exchanges, governance of market operations and trading practices, and to a large extent, in its own way, for prevention of fraudulent and unfair trading practices. Well, what were the limitations? Was that it was designed to primarily regulate the contracts and recognition of stock exchanges, not the broader securities market ecosystem. In the evolutionary journey, the market has evolved as a dynamic creature. So probably this old, just after the Independence Act, was not catering to the need of today's market. It did not address the new hybrid instruments that we have seen emerging. Probably Sahara is a reminiscent of that problem. Then regulation of exchanges under SCRA. It operated separately from intermediaries. It was only focused on exchanges. And then the investor protection measures were not central to this act. Now this is being all put in form of this new code to be dealt in a comprehensive way. Next slide, please. For SEBI Act, it came after the aftermath of scams and was in response to the weak architecture of the market from the governance point of view, and converted what was earlier an administrative body into a statutory one. This act established SEBI as the central regulator of securities market, conferred regulatory, investigative, and enforcement powers, gave it a statutory clothing, and also oversight over or supervisory jurisdiction over the intermediaries, including their registration, how they conduct themselves. And then, of course, the most important philosophical mandate for SEBI was to protect the investors and also promote their education. What was found as a limitation of this act by the time we entered 2025 is that it was conferring powers, but it was not integrating the full market framework. The core processes, which is one is the regulatory side of it, the policy side of it, and the enforcement side, they all evolved through delegated legislations. Principles such as proportionality, they were not they were somewhat, if not confused, they were somewhat unclear in the old act. Depositories Act, as Damodaran sir said, was not required in the first place, but it existed and it provided for establishment and regulation of depository institutions, dematerialization, rematerialization aspects, rights and obligations of depositories and participants, and the governance and settlement mechanisms. The issue in this was that it did not address other conducts. It only dealt with a very niche area relating to depositories and relied substantially on SEBI Act and regulations for purpose of supervision and enforcement. So it had its own limping leg in a sense. Now coming to the limitations overall of the earlier framework, the statutory design was fragmented, and I just quoted from Supreme Court's observation. There was a great incentive felt by wrongdoers in the arbitrage that they used to take in regulatory matters. The enforcement powers were dispersed, overlapping, and there was an absence of single source of reference for the market participants. And it is used to say, even before the ink is dried, there used to be some other amendments, and even for professionals, it was a very tough subject to pursue. Next slide. So what does the Securities Market Code changes? It brings a consolidated framework. Although it is introduced in Lok Sabha, not yet enacted, it is a modernized version of these three laws and ought to be future-proof. Why it matters is because it's less fragmented, it is poised to give more certainty, faster enforcement, and clarity in matters of enforcement, as I shall cover later very quickly, and stronger investor protection. So SMC, apart from the consolidation that it apparently offers, is or could be a GST movement for securities market framework. What are the key differences which distinguishes this code from the erstwhile provisions? So you would see that Supreme Court had issued an instruction for all the courts that their interim orders would continue for 6 months, and they need to be upgraded if they have to continue between from that period onwards. So a similar kind of a provision, maybe based on the same logic, is introduced, wherein the interim orders are issued for a period of 180 days. Although this is not cast in stone or iron, these could be extended or modified with reasoned order. And there was a whole lot of criticism of the open-ended interim restraints that has been catered to in the Securities Market Code. It offers a whole lot of decriminalizing provisions. Penalties have been made more severe, but at the same time, the overall ethos of the government to decriminalize laws and thus to reduce the burdens from the court, unnecessary burdens of prosecution from the court, that is also seen in this new Securities Market Code. As Sir also pointed out, it also strengthens the board, increasing the existing number of 9 to 15, 5 whole-time members on the board, enhances the institutional capacity, or at least aiming for that, and alongside specialization and governance. And then there were certain powers like making complaints which were available in consultation with government that is now vested with SEBI. So on the functional autonomy part also, this provides more power to SEBI. And then the reintroduction of the ombudsperson norm, which I think Damodaran sir captured, so I'm not getting into it. What are the key features of SMC? It is divided in 18 chapters, 4 schedules. SEBI is the central regulator. It covers listed companies, intermediaries, market infrastructure institutions, self-regulatory organizations. By the way, self-regulatory organization is the model that we adopted long back. This Securities Market Code gives it a statutory clothing or institutionalizes it, although it has been adopted earlier. And then technology neutral and instrument agnostic approach is there in the Securities Market Code. It applies to both domestic and some specified cross-border securities transaction as well. I'll just quickly take you through what are the crucial new definitions. It for the first time defines what is a securities market, what securities are. Earlier it was fragmented. It was defined in SCRA. It is now it has not been now been brought all together. Market infrastructure institutions have been defined. Intermediaries are defined. Pooled investment structures, investment schemes are defined. Market abuse has been defined, which is much wider than fraud or unfair trade practices. Maybe it's an amalgam of both. Unlawful gains have been defined now in a way to include both profit and loss averted, which was also already clear in the earlier laws as well. Now, I'll just quickly talk about what are the novelties. So one is that it institutionalizes the self-regulatory organization. Chapter 4 is dedicated for that, which talks about the intermediaries, which would be operating on the self-regulatory organization model. Investor charter and ombudsperson framework is something which is novel to the Securities Market Code. And it also recognizes the regulatory sandbox framework as a statutory feature, rather than the one which came through subsidiary instructions, as this new code refers to circulars, master circulars as subsidiary instructions. And then statutory status to NISM, National Institute of Securities Market, to do the capacity building, certification, training, and research, truly a move towards strengthening the investor education or the overall education in the market framework. Then there are certain terms that the participants would be familiar with. I'll just quickly give a brief overview of them. Board is SEBI, which will be doing policy. regulation and oversight alongside enforcement. The enforcement part of it will be taken care by um, investigation wing. Investigating officers have been defined here. Adjudicating officer has been defined in a new, fresh way. Recovery officer, the concept remains the same, whose role would come into play after the investigation and adjudication are done. And SAT is the appellate tribunal. It remains so. Supreme Court, it remains so as a second appellate body, only on the questions of laws. The SROs have been institutionalized. So if you would see the architecture, the regulatory architecture, apart from the enforcement wing, you would see the inspection comes at the top, then investigation, interim orders have been provided for. There's clarity with respect to interim orders, which can be up to 180 days, and with review and recorded reasons, it could be extended to up to 2 years. Adjudication, wide powers have been vested with adjudicating officers. Earlier, they could only impose penalties. Now, apart from the penalties, which in certain cases run up to 100 crores, these adjudicating officers could impose, I mean, sky's the limit, so to say, all sort of measures to deal appropriately with the situation. What was used to be 15J, which are the factors that used to be considered by adjudicating officers while imposing penalty, that list has been that list has been expanded, and it does not only talk about proportionality, but it strikes a balance between two concepts. One is of proportionality, and the second is of deterrence, to send right signals in the market for the wrongdoers. For investors, certainly there are provisions which would allow enhanced investor protection. India's rank in that benchmarking has already been increasing. Time-bound enforcement, faster reliefs, statutory restitution, that is a new thing that has come. Apart from disgorgement, the restitution aspects are also there, which we would see in the final law. Investor charter and ombudsperson, as I said, and the procedural safeguards and appeals. There are plethora of provision which make it clear. Even the adjudicating officers have been given power to rectify their order within 30 days of passing the order, if in case there are some apparent error on the face of the record. I think with this, one thing which is very important to be looked at is clause 97 onwards to clause 109, which talks about the penalties. And I was shocked not only shocked, but I was intrigued by looking at the kind of penalty provisions that we have. Earlier, the highest penalty that I saw was 25 crores or 3 times of the profit. But now it is up to 100 crores or 3 times of the profit at certain instances. So certainly, from deterrent point of view, the law has gone a major overhaul, and that's all about it, sir, in a nutshell.
Thank you very much, Ravi, for giving overview of this. Now it's a time that we should listen to the experts, those who are working day and night. They have worked and they have used this law as a deterrent. Now they have other side of the table. So there's a combination of this. So I will request Mr. J.N. Gupta, sir, to say about this particular law on the investor protection side. And the important thing is the deterrent of 100 crore will be there, or something more has to be done. Over to you, sir. You are free to choose and suggest. But the main focus is, sir, wherever issues are there where we can modify and suggest to the Parliament Committee, that will be very strong, sir.
Thank you very much, Pawan. Thank you very much, corporate professional, for giving me the opportunity to talk on this. Although I cannot say that I'm expert in that. I think I have just glanced through it. So I have a couple of issues. I would say this is the first step towards some sort of a rationalization and restructuring, because I had always been wondering that why there was a need for separate Securities Contract Act and rules when SEBI was there. So it is a step where everything is in one place. The most important thing is this, that here they have said, as I understand from your note, that the entire regulations is going to be some sort of a principle based rather than the detailed one. Then the first question would come, and which I would want is this, that all the existing regulations, they are there. They are not principle based. So as a result, what happens when the matter goes to the court and everything, the issue is decided in what is there in the language, where the comma is coming, where the full stop is coming, notwithstanding, provided this, provided that. I recall that there was an attempt to make the insider trading regulation a regulation where the rationale was explained and everything was done. So I would say that this is the first step. The next step will have to be where all the existing regulations will have to be redrafted in the light of what is the intent of this regulation. If the intent is clear that we need to have a principle base, because if you look at most of the SAT pronouncement, in which I many times wonder that why the SAT has turned down, you will find that it many cases narrows down to the fact that SAT has that the law does not say this. But if the law says the principle and apply the principle, probably most of the problem that the investors face, or most of the problem where SEBI loses against a fraudster or against a wrongdoer and the investors are suffering. So the first thing for investor protection would be that make all laws a principle-based laws, explain the rationale, and do not let interpretation by this. I was reading one more page that the judicial pronouncement should be the frozen and they should become the benchmark for this. I think that if it is done, although it will be very difficult because they cannot be like a historical rock of Gibraltar that they will be, especially they will change, but at least they will give a semblance. And I very much recall a case, and I don't know what has finally happened to that case. In PNB Housing Finance case, the matter was to be decided that what is important, article of association or not. And before that, Supreme Court had already decided in Tata case that articles of association are bedrock of the company management. And what happened in that case, the two members of SAT gave a differing view. And if you read that, you will feel that, oh, it was like a debate between the two members rather than attempt to adjudicate the issue and give a judgment. So if that happens, it will be a very, very important thing. One area where I feel I saw in the note and in the act, where the disgorgement is talked about. And they said that disgorgement, if the amount is sufficient, that is a wrong notion. I will tell you why. Say, for example, there is a 100 rupee loss, and by all means, you have disgorged 50 rupees. So it can't be all or none situation. At least the people who have suffered, give them 50, proportionate. So it can't be that if you are not able to collect 100. The one thing which again I would look, that in many cases, the penalty, etc., goes to the government, into the consolidated fund of India. In my opinion, all the penalties, etc., are the result of sufferings of the investors. So that money, rather than going to consolidated fund of India, should be used for the benefit of the investors who have lost. Then there is, again, I saw in your note where it said that the law should not be reactive. I totally agree with the law should not be reactive. But what has happened, my experience showed the reaction is because there is some failure. And that is where the problem comes, that when I am following the law, I am not following the spirit of the law. I am trying every means to see that how I can follow the letter of law without following the law in spirit. As long as that happens, the law will have to be reactive. It cannot be proactive all the time. The next point that I wanted to make is this. We have been all the time, whether it's SEBI, everywhere, government, we talk about ease of doing business. Now, I understand from ease of doing business is that ease of procedural issues. It should never be meant to ease of diluting the intent of the law. Many a times there is a debate when we say that ease of doing the business is translating into how to reduce the or dilute the law. No, it is not. The law has to be for an objective, and that objective has to be met regardless of anything. Then there is many other issues. Now, this law has defined certain things. But if you look at this, long back there was an issue that what is the securities market instrument, what is not the securities market instrument. There was a lot of fighting between IRDA, or rather, I will not say fighting, lot of dispute or disagreement between IRDA and SEBI, whether the insurance scheme which were equity based are to be controlled by SEBI or IRDA, and that is still continuing. There was an attempt earlier when the Financial Services Authority, the whole authority was to be created where all the regulators to be merged, but that has not happened. But I think this is the first step towards that. That is not wrong. The other important area is this, the definitions. In this, you have defined certain things, but at present in many regulations of SEBI, any word that is used, say for example, promoter or person in control or what is control, they are different meanings in Income Tax Act. They have a difference in RBI. They have a difference in SEBI, or within SEBI regulation, there is a difference of that. So that has to come to act. The other most important thing which I say, even today, across all the regulator, one term doesn't mean the same thing. What it means at RBI, what it means at SEBI are two different things. And I will give you an example, or rather I will say, term of independent director. Now, as far as SEBI or Companies Act is concerned, 8 years is the way after which the independence is 10 years is after which the independence is vitiated. Where RBI feels 8 years. So my issue is that if conceptually one believes that 10 years is the period where then it can't be different for RBI. So what I will say that this is a beginning, but it needs a lot of work to be done and finding out where the rationalization is required. So I think I will stop at this and then.
Okay, thank you very much, sir. You have raised very, very important thing. One is the regulation have to redraft on the basis of this principle. Then security market definition and the different meaning on different should be clarified when they are doing this task. Thank you for your suggestion, and I will expect that you, as a academician, also you must be preparing some note. You can send it to us also. We can add that point. Thank you, Jay Gupta sir.
Thank you.
Now come to the Mr. Nagendra Parekh sir. As you are aware, Nagendra Parekh sir is also chartered accountant, and he was handling when the option and future came. And I think when I was in the capital market company, I interacted with him because my company was doing the old days Badla transaction, and that was a new option future. And I met Mr. Parekh. The way he was explaining the schemes, the things, I think it was a unparalleled knowledge of this area. So, Nagin sir, your take on this and your suggestion, and if you can guide something on the new instrument, are we meeting the international standard on the various instrument, or something new are we doing? Over to you, Nagendra sir.
First of all, thank you for inviting me to this seminar, and I am very happy to see my all senior colleagues and colleagues on the panel and sharing their views. It's a very important subject. In my view, what Mr. Damodaran sir had said, I tend to agree with him that this code is more of a consolidation than something offered new. In my view, a little step should have gone further and something new should have been added, which is the need of the hour. Looking at the present scenario when the automation and AI is taking the lead, some provisions should have been incorporated with the foresight that these technologies are adopted in the securities market as quickly as possible. Though there is no bar on that, but still I think explicit provision would have helped. You asked me to talk about new product. New products are always being thrown upon by the market. It's a regulator to make them proper regulation for them. But considering my individual view, I think that the way the situations are turning in the market and geopolitical situations are turning, and the way gold has emerged as a very big commodity to trade, I don't see a provision in the Act to deal gold as a security, because what we are talking here is regulation for securities market. Gold is not covered in the security, even though there is a provision for regulation of vault manager. For what vault will do unless some commodity is being stored there. Vault manager has covered, but they are not on the not gold. Is a gold paper could be a security, but not a gold. I think there is a need that we should have a spot market also regulated by the SEBI. It could be in some way, may not be for all commodities, but for certain commodities, spot market should also be regulated. Now, the new financial instrument, it talks of one beautiful thing, which says that the contract which are traded between the member of the stock exchange, same continues, but they have made an exception. The central government may notify otherwise. I think that the time has come where liquidity needs to be consolidated. We have separate stock exchanges trading the same product. What is the need of that? You should look at the scenario where in USA there is a national market book, NMS, when all orders are pooled together. I think the framework should have talked of that. If the liquidity is pooled together, clearing settlement could be unified, and all liquidity will come in one place. More price discovery will take place, and manipulation will be restrictive. The new innovative idea of that sort should have been considered. I think this regulatory aspect, it should also get way to those things. There is a provision I see that they are going to regulate index provider. I think the world over, I think is not regulated, but here is thought of that they are going to regulate index provider. Index provider is a community which gives the index and which is relied upon by the people or not relied upon the people. It is their choice. So the popularity of the things and the accuracy and the sovereignty of the things will make the index popular. Main thing comes the SRO inspection. We talk of the same thing in the regulation. We give the SRO. SRO is not only for registration, it is for regulation also, self-regulatory organization. Okay, it will become self-registering organization only, then his SRO is fine. If you want self-regulatory organization, then inspection power should be there with them. For many, and most of it should be taken care of by the automation and application of AI. Procedural-based regulatories should not be botheration of the regulator. What compliance has not been done, what regulatory paper has not been filed, some filing miscues, all those should be part of the SRO. It will leave a lot of burden from the regulator. When regulator comes, it should be investigating the matter, which is not part of routine. This is something different. And we come to investigation. There is a very important aspect which needs to be looked into. That so far we have been doing investigation for only transactions related to securities market. While dealing in securities market has been the benchmark for doing the investigation. So we had a limitation in SEBI while doing investigation for other things, like for disclosure related problem, for accounting frauds, for other related frauds, which are not while doing in the dealing in securities market. I think those need to be covered explicitly in the code if you want to regulate that. But there is a conflict of interest there. The Companies Act also provide for securities fraud regulation. So there is a separate regulation for that, for corporate frauds that need to be regulated by the SFIO. So that balancing has to be done. Whether SEBI should look into that or not to look into that, because there is a specific role assigned to that. So there are many things. Ombudsman has been brought in. Very happy aspect. This has been tried in the past also. Ombudsman will give order, but how enforceability the order will come? That is more important thing. I as an enforcement officer pass an order against somebody, but who's going to enforce that order? That mechanism is very important. Otherwise, that enforcement will not be workable. So that Mr. Jain Gupta has touched upon principle-based regulation. Very important aspect. Principle-based regulation need not define all these things. They give the simple principle, and then detailing has to be done by the regulator himself. That would have been a better approach in the present time. Here the code itself is so detailed. What is laid out is a rule-based regulation and said to be principle-based regulation. This is my view. So these are small observations, and I think we can go along and say more on this subject. Thank you.
Thank you very much, Nagendra sir. Your point of vault and gold, that is point in using of AI and the index provider point of view and the role of SRO, where the regulator role should be reduced. That is very, very important. And your knowledge on the subject is we have seen in the past also, and today also you have given very short but very impactful. Thank you very much. Now come to the Saucer. Saucer, you have, I think when I met you first in 94 and 95, you were in the finance ministry looking after capital market. And till then, we have seen your journey from this to NSC, then SEBI, then CCI, and then other thing. And now you are advising various aspects also. Sir, what is your view on this? And the most important is regulatory governance issue. In the entire proposal of this new code, where you find the governance of regulatory government issue will be there. Over to you.
Thank you, Mr. Vijay. Am I audible?
Yes, sir. Yes.
Thank you so much for giving me this opportunity. I think the Constitution of India that provides for the governance in government. We have the Companies Act that provides for the governance in companies. The Securities Market Code, I would say, for the first time in Indian context, gives a framework for regulatory governance, though it has been done in the context of securities markets, but I think this has potential to be the model for the entire financial sector and even beyond. Why I say so is because, SEBI has been the India's first major regulatory experiment. And with many regulatory issues emerging first time in the domain of a security market or SEBI, and those have been resolved. And that resolution has been a precedent for other regulators. You mentioned about the 94, 95. That was the time when we thought of empowering SEBI to impose a monetary penalty, and there was a tough resistance. How can an entity outside government impose penalties? It was agreed subject to certain conditions. One of the conditions was that there would be a regulatory tribunal. This model has been replicated across other regulatory domains. SEBI started public consultation in 2002, and that became the model for every other regulator. So SEBI has been pioneer, or at least the problems or issues resolved in the domain of SEBI stroke security market has been the guiding path for other regulatory domains. The Security Market Code, I think, is actually a decisive shift. What can be considered as a regulatory architecture too. In 94, 95, you referred to. In fact, I would say that in 92, whatever was created, that was a sort of agencyfication. In 1995, Amendment 25th January 1995 was a kind of empowerment of the regulator. Now the focus has moved to regulatory governance, from agencyfication to functional empowerment to regulatory governance. I would discuss this regulatory governance. There are many dimensions to it. I will cover 6 aspects. One is relating to, 3 aspects relating to that the regulator is a kind of state, the state or government within the government that performs some amount of legislative, executive, and judicial functions. So these 3 aspects, how the code has taken up this legislative delivery of these services, legislative services, executive services, and judicial services. Then I will come to 2 or 3 pillars like the board composition, the accountability, and the independence of the regulator. Come to rule making, the regulation making. So in securities regulation, the volume of regulations vastly exceeds that of the statute. The subsidiary instruction, now a term that has found place in the statute, that is defined to include circulars, master circulars, and guidelines, which the regulators, not only SEBI, every regulator has found a convenient way of prescribing regulatory norms through circulars, and having a situation like we call circular Raj, a kind of slogan has come up. The way we had dealt with the license permit quota Raj in 90s, we need to deal with the circular Raj. So now that has come. If now circulars cannot be used to prescribe regulatory norms, these the subsidiary instructions can be used only to provide the clarifications. And that must be done only with an application of mind at the board level. The chairperson or whole-time members can do it, and they will do so in consultation with the advisory committee. So that means all regulatory norms have to go through the strict separate subordinate legislation, which will go through the process of public consultation, discussion papers, provide comments and approval by the regulators board. And both the subordinate legislation and subsidiary instruction, they all must be placed before the parliament. Not only this, the discipline extends even to the bylaws of market infrastructure institutions. They must promote the objectives of the code, non-discriminatory, proportional, all those principles are there, but they are subject to similar public consultation, SEBI approval, and these require also prior publication. All the instruments that you use to prescribe any kind of regulatory norm has to go through a sacrosanct process. Come now to the adjudication part. We had so far multiple siloed proceedings, like the inquiries you have that leads to suspension or cancellation of a registration. You have adjudication that leads to only monetary penalties, or you have Section 11, but there is a separate category called prosecution. But all the other three, there is a structural flaw in the sense that when you decide to take a particular enforcement action, let's say adjudication, you are making up your mind that this contravention must end only in a monetary penalty, and even if the adjudicating officer finds that it should be something else or suspension is warranted, he is helpless. That means we actually prejudge this circumstance without having the full facts on the table. Before concluding the inquiry, you decide what would be the outcome. So therefore, it was problematic. But now what has happened is, it has combined all this with only one person. He will decide what kind of action is warranted or most appropriate in the circumstances. And the process, as usual, will be grounded in principles of natural justice, show cause notice, explaining the alleged violation, and emphasizing this time that enclosing the documents and material relied upon, and then give an opportunity to respond. Unlike we had several matters where Supreme Court directing give this document and give that document. It's a much more clear now, and this must end with a rescind order. And much more explicit provision that the outcomes must be proportionate, that must consider intent, duration of contravention, frequency, the amount of unlawful gain, the harm it has caused to investors, and the impact on market integrity. Also consider all aggravating and mitigating factors explicitly. Even the settlement of administrative proceedings, settlement of administrative and civil proceedings, that must also reflect the gravity, nature, etc. of the contraventions. And the code, another important feature it has brought in the space of adjudication is the discipline to the interim orders. It allowed the regulator earlier to issue the the interim orders pending or on completion of investigation. But at times we have seen decades have passed, the interim order is in force, and the person, ultimately this may result in a punishment of X years, but the person has already suffered X plus years. So this limits this to 180 days, preferably after a hearing. And in any case, with the application of mind at the board level only, it can be extended as an outer limit up to 2 years. That means the interim order really means interim. It's an interim measure, actually, not an order, you can say. And it remains protective and not really the punitive. The third service it does, or third function, is the executive function. Now it has unified the process of a registration, starting from the application, scrutiny, grant of registration, the conditions, the refusal, surrender, standardized and due process embedded throughout. And so quite often, particularly for inspection and investigation, there are the timelines. And these investigation, inspection, they will start with a written order, follow prescribed procedure, time limits, transparency, proportionality, and the extension should be rare, and they cannot initiate an investigation or inspection after 8 years from the date of contravention, something like the law of limitations. That means there should be an urgency with the regulator to start a process, complete the process. The bigger concern which we all have dealt is the separation of powers, which is different in a sense in the government, in the normal government state apparatus, as compared to the regulatory bodies. In government, what happens is actually we do not really have any concern of fusion of legislative and quasi-judicial powers. There is always a concern about the executive and quasi-judicial powers. Government has addressed, regulators have addressed to a different extent. But the fusion, because in the regulatory body, the person who makes the law also imposes and takes the enforcement actions. So I think there has been some separation, not adequate, but the reinforcement has been done to the separation of adjudication and execute. That means person associated with the fact-finding, inspection, investigation shall not be the disciplinary authority. And once he is a disciplinary authority, he will not deal with an investigation, inspection relating to those parties. So separation, in a sense, not strict kind of sense, prior to and post, after the quasi-judicial action is taken, has been ensured. Now I come to the 2-3 pillars. The one key pillar is the board. In fact, one thing it has not addressed, it should have addressed, is that it says that board is a board which is a body corporate. Then it says board comprises of chairperson A, B, C, D. The board which is a body corporate and the board which is a comprises of these persons, these two boards are different. And not only in SEBI, everywhere this confusion remains. What the organization, corporate or the institution SEBI can do and what the board of governors or board of members can do, that clarity is missing. Nevertheless, the primary responsibility of the board is to act as a hands-on principal that holds the management accountable for conduct and performance. And this requires an interface with the society or external to the organizations. That means you need members who participate fully in the decision making, have a stake in the outcomes, that remain sufficiently detached from the day-to-day operations and not beholden to the management. And this is the precise function the external or part-time members perform. And like we have prescribed in corporate governance, the majority should be the independent directors. Ideal would have been to provide for that. That means if it provides for 15 members, which is unwieldy, I know, but if it is provided for 15, 8 should be external. Today it provides that chairperson, nominee members, and not less than 5 whole-time members. It could have been not more than 5 to 7, whatever you want. The limit should have been on the number of whole-time members, not on the part-time members actually, because in this situation, there can be a decision that we will have all 15 as whole-time members. That means nothing is left for part-time members. Another troubling feature which it could have addressed is the nominee members. The nominees of finance, Reserve Bank, those kinds of things we have seen from our experience how effective or how ineffective they have been. When you have the arrangements for coordination, when you have powers to give direction to regulator, you don't need this kind of arrangements. So except for this, I think the board composition has moved quite a bit as regards the, I can say, reasonably a balance, mix of part-time, full-time, and the prescription that they will be from different disciplines, at least from one from the technology, one from security market, and over and above this, the provision for the not very elaborate, but the mechanism to address the conflict of interest, particularly for part-time members. The upper age has been expanded, increased to 70, expecting that those who could not come during their active lifetime, they could now come as a part-time members, because we want part-time members as a balancing the factor. So it is important that not only for whole-time members, even for part-time members, you need a more effective conflict resolution framework. So that has come. As regards the independence part, it reinforces, retains the initial provisions like the functional independence. It can frame regulations without going to government. That came in 95. Even today, we have the statute in 2025 also statute coming, requiring the regulator to notify regulations with the prior approval of the central government. So those kinds of independence it has retained. It can adjudicate contraventions on its own without recourse to any organ of the government. It preserves the autonomy of financial and human resources. One can argue about the surplus funds being transferred to government. That's a very minor thing. I'm not devoting time. But that basic autonomy remains. The fixed tenures, removal safeguards, post-tenure cooling off on employment, those things will work. And at a deeper level, actually the regulatory independence depends on, critically on the professional strength of the leadership, particularly the chairman and whole-time members, who can withstand. Actually, we talk about regulatory pressure, regulatory capture, that we loosely mean that capture by the regulated. But actually what happens is that here the chairperson and whole-time members who can't withstand pressures from the organized interest or pools of fear and favor to avoid regulatory capture. That's why a term of 5 years to me is insufficient to acquire that kind of domain mastery to avoid regulatory capture. And in fact, I am happy to see that this has found place in the economic survey yesterday, that which has made out a now case for regulatory appointments and then tribunal appointments, that they be appointed for a career. Unlike if somebody does not wind up his profession to join High Court or Supreme Court for a term of 3 years. So if you want the capacity, you need to give them a job till retirement. That retirement must be the same for regulators and government, not leaving a possibility that someone comes after finishing his career at 60 to the regulatory bodies. So therefore, regulatory independence would be better served by recruiting capable individuals at a mid-career and offering a tenure that runs until a fixed retirement age, which is aligned with the government service. And that should, irrespective of the age of entry. Nominee members I talked about, their role, that comes also on the way of independence. In any case, a discomforting feature that I found in this code is that the government can exempt the public sector from several provisions, starting from issue to corporate governance. These kind of things are problematic. Accountability, I think it establishes an elaborate accountability framework, as I discussed about the discharge of these three kinds of quasi-legislative, executive, and quasi-judicial functions. And beyond this, it elevates the transparency from a matter of good administration to a statutory obligation. SEBI is required to maintain an universally accessible electronic database, publish regulations, subsidiary instructions, and orders of executive officers and ombudsmen, review those regulations governing the meetings of governing board, and publish its decisions. It mandates SEBI to conduct periodic research. Regulatory impact assessment, it has not told in case of every regulation, but it has made a general provision that SEBI shall carry out regulatory impact assessment. Ideally, it should have been for making each piece of regulation. It also provides for audit of functioning of performance of a security market and service providers and publish the results. This would have been still better served if it had provided for an performance evaluation by an external agency like the IBBI did an external evaluation IBBI through NCAER. So broadly, I would say that the reforms efforts, whatever has come, that recognizes the need for objective, formal, and periodic assessment of performance of regulators. Some regulators, I gave you an example, if IBBI, if SCRA has done to some extent, ideally it could have been, required or mandated an independent external evaluation at defined intervals, consistent with something like this. Today, SEBI requires the external evaluation of market infrastructure institutions. If market infrastructure institutions need an external evaluation, SEBI of course needs. The code addresses conflict of interest to a large extent, but the regulatory architecture, as it has come out or articulated in the SMC, as I told earlier, has relevance beyond the security market. Its provisions on instrument design, governance, transparency, accountability could be distilled into a standalone regulatory governance code. Such a code could serve as a template for establishing new regulators and as a benchmark for modernizing existing regulatory statute and allowing sector-specific laws to focus on substantive regulations. That means there is a part one kind of thing which applies to every regulator, that's the governance aspects. And part two relates to the security market or a telecom, depending on the subject area. And what is the standard arrangement we have, say, United States or United Kingdom? Hopefully, this gets into a code of regulatory governance. Like as I told you, Companies Act is a governance code for companies. Constitution is a governance code for government. We need also a governance code for regulators. Thank you.
Thank you very much, sir. I think your last point is very, very important. The governance code for the regulator is very important and it's a long way to go. And it will bring governance because we tell everyone to be governed. Now, there's a term that at this present moment, when the law is making, we should do this. Thank you very much, sir, for your deep analysis of this particular law and the governance aspects. Now come to Nagpal, sir. Nagpal, sir, you have worked in SEBI since long, and your experience is always in various segment, whether it's investigation, whether it's other intermediaries and market. So many area you have worked. Your view, sir.
Thank you, Pavanji. A lot of discussion has already taken place on the Security Market Code 2025. I shall be brief in my presentation. Now, what I find is that a number of practices and policies which were already implemented have now been formalized into the Security Market Code. For example, investor charters. SEBI has already introduced investor charters for various intermediaries. Then advisory committee. I think immediately after passing of SEBI Act, SEBI introduced the concept of advisory committee, primary market, secondary market, and later a number of committees have been set up by SEBI. Then publication of the regulations before notification, that practice is also being followed. Then inter-regulatory cooperation. SEBI has there is a very high-level committee in the country chaired by the finance minister, and then there is a technical committee chaired by the RBI governor, and there is also a concept of conglomerate, which where all the regulators participate. Then sharing of information with the international regulators, that provision is also there. So what I find is that number of practices have now been formalized into the Security Market Code. Now I shall come to the specific provision. I agree that size of board comprising of 15 members is too large. When we have advisory committees having experts from the market, 10 full-time EDs and 5 full-time members, then there is no need of having 15 member board. Second point is the ombudsman. Perhaps people are not even aware of that SEBI notified the ombudsman regulations in the year 2003 and repealed the regulations in the year 2023 without appointing any ombudsman. I don't know what is the need felt now, why this concept has been reintroduced in the Security Market Code. Now, there is a well-defined score system handled by SEBI. Then there is an investor grievance committee in the stock exchanges, arbitration, appeal against arbitration. And apart from that, SEBI has also introduced online dispute resolution mechanism. With all that mechanism, I don't think ombudsman will be required. But if any, I don't find any specific grievance which can be addressed by the ombudsman. Now, other point is that inspection and investigation, which must be completed within a period of 6 months. This is a welcome step, and practically it is possible to complete any investigation or inspection within 6 months. And the code also defines that there should be a notice for the inspection and investigation. My view is that when SEBI closes any inspection and investigation without imposing any penalty, that information should go to the entity which is subject to inspection and investigation. When penalties are so stringent, that entity is always under fear that SEBI may come out after 1 year, 2 years, or 3 years with some heavy penalty. So therefore, when SEBI is closing any matter without penalty, that information should go to the entity. And this is also required from prevention of corruption point of view. Other point is that interim order. Again, 6 month time has been given. And this is the area where SAT has passed strictures against SEBI a number of times for delaying in investigation, passing the interim order after too much of delay, and not completing the investigation after passing the interim order. Now, this new concept, new timelines, I hope will be implemented by SEBI, and there is a provision of extension, but my suggestion is that this extension should not be given in a routine manner. By and large, 80 to 90% investigations must be completed within 6 months. After interim order, investigation must be done within 6 months. And any extension should be given only if it is required after considering all the aspects. Now, other point is that I find that there is a provision of supersession of the board of the market infrastructure institution by the central government. Perhaps people are not even aware of that in the Securities Contract Regulation Act, Section 11, there is a provision that SEBI can supersede the governing board of a stock exchange. I don't know whether this is a conscious decision that now this power should be exercised by the central government. I think this is a matter of debate whether SEBI can exercise this power as was the practice earlier. Now, other point is that I find there is a chapter on penalties in the Securities Market Code. Penalties have become very stringent. Earlier, maximum penalty of 1 crore for certain violations has now become 10 crore. Earlier, penalty of minimum 5 lakhs and or 5 crore has become now 25 crore. And earlier penalty of 25 crore has now become 100 crore. Now, I find that adjudicating officer will find it very tough to take a decision while imposing penalty because such a wide discretion has been given. And what is more disturbing is that the court says that where there is a profit and or loss caused to the investor, 3 times of the profit or loss penalty can be imposed up to 100 crore. Court also says where there is no gain or loss, even in that case, penalty provision is 100 crore. I don't find any reason why penalty should be so huge amount when there is no gain and no loss for the investor and no gain for the entity. Other few points. I agree that each and every circular bylaw need not be placed before the parliament. Only regulation should be done. And there is a provision of that SAT should preferably pass the final order within 6 months. It is a welcome step. Now only we have to see whether it is really implemented. And other point which I find is that after any surplus which remains after the adjustment of the expenditure, for the last 2 years expenditure, SEBI can transfer to the reserve fund. And remaining amount should be transferred to the Consolidated Fund of India. Now, this will affect the independence of SEBI. And earlier, the entire amount, all the revenue used to remain within SEBI. Now, I am sure that whenever there is a financial sector assessment by the World Bank and IMF, they will definitely point out that this provision is affecting the independence of the SEBI. Now, new code, while in this, if you see the provision of Section 15J of SEBI Act, there are only 3 provisions which could have been considered by the adjudicating officer while imposing penalty. Undue gain, loss caused to the investor, and the third, repetitive nature of the violation. But new code has given a lot of flexibility to the adjudicating officer. He can consider all the aggravating and mitigating factors. He can see the frequency of violation and duration of the violation and penalty imposed by the other adjudicating officer in similar cases. And he can consider a number of factors, but which is a good thing. But 100 crore rupee penalty, I feel, will be a very difficult for the adjudicating officer to decide. So these are the few points which I wanted to mention. And one more point that we have discussed about the subordinate legislation. I think this concept has worked very well within SEBI, and there are a number of checks and balances, and the provision of describing the procedures and detailed guidelines in the circulars. I think this has worked very well in SEBI. And now the code clarifies that all the subsidiary regulations violation, like circular violation, will be considered violation of the regulation. I think it is a good thing. And there was an order by SEB many years back that any violation of circular is also will be considered violation of the regulation, and circulars are binding on the market participants. And last point which I should like to mention is that Mr. Damodaran talked about the dominance of lawyers and accountants. Now, SEBI has appointed different type of educational background officers. That concept has worked very well. Based on my experience, I can say that dominance of lawyers and this accountants is not required. And last point, I would say that whatever the contents of the Securities Market Code, ultimately it will depend on the implementation. How SEBI implements. I give you a few examples that 28 years after passing of SEBI Act, we found that there were 32 stockbroker defaulters, one after the other during a period of 3 years. It took SEBI 3 years to plug the loopholes. Second point, inspection of documents and cross-examination. These issues come up quite often. Every time the entity had to go to SEB or they have to go to the court. I fail to understand why these issues are not settled. And so ultimately, it will depend on the effective implementation of the code. Thank you.
Thank you very much, Nagpal sir. Really, your experience was reflecting in your discussion and your study of this code. Thank you very much for this deep knowledge. Time is short, so I'm not giving things. Now come to our another stalwart, Mr. R.S. Luna, who was Executive Director, who was a legal division. And if suppose he was in today, if he's in SEBI, then this code related to him directly. So now, you, sir, what you feel about this? What changes are good or bad? How you think the modification should take place? Sir, unmute yourself, please.
All right.
Yes, sir. Okay.
Am I audible?
Yes, sir.
Yeah. Thank you, Pawanji, and good evening to all the participants. Within the limited time allocated to me, I'll try to touch upon some of the new but critical provisions of the code, particularly in relation to the enforcement powers of SEBI. Most of these provisions are in the right direction, but perhaps running short of achieving the intended object. First and foremost, provisions of this nature are in respect of inspection, investigation, and adjudication. Look at clause 13.1 of the code. It says, board may appoint chairman, whole-time director, or any other officer of SEBI as investigating officer. I find this provision a bit absurd when I observe that chairman and whole-time member can be appointed as the investigating officer. As per the current practice, the investigating officer is appointed by the whole-time member. And let us assume that in the new scenario, chairman is appointed as the investigating officer. Firstly, whether the entire board will be involved in appointing chairman as the investigating officer. And when the investigation report is given, the actions are to be taken. Who will take action on that? Who will decide further enforcement actions? I mean, these are the very fundamental issues. Probably, in my view, they have not been looked at. There has not been much deliberation when we are putting the name of chairman and whole-time director to be appointed as a investigating officer. Second, in the investigation itself, we are saying that the investigation to be completed within 180 days. This period may be extended by the whole-time member. Now, for how long this period can be extended is not clear, is open-ended. Why not we provide that this period can be extended by further another 6 months at the most? Mr. Nagpal just now said that investigation is possible to be completed within 6 months. And in some cases, exceptional cases, if it is not possible, maybe another 6 months. So the law should provide for that. This is the maximum period within which the investigation must be completed. Another very important provision which they have put is that the investigation will not be initiated in respect of defaults or contraventions after the expiry of 8 years. That's a very good step. But it says that even after expiry of 8 years, in two circumstances, the investigation can still be initiated. And those two circumstances are where there is a reference from an investigating agency, or in the opinion of SEBI, the default or contravention had or have any systemic impact. Fine. Maybe we can consider the reference from the investigating agency, but then again, we must put some kind of caveat that investigating agency must be investigating already some connected matter, and that is why they want SEBI to open investigation from the SEBI angle. Second, that reference also should have some time. It's not that after 20 years or even more, the investigating agency can request SEBI to open this investigation. Then the whole object of putting this provision is defeated. If at all, there should be time limit that, let us say, originally it is 8 years and it could be another 2 years, but not beyond 10 years. That is more than enough if we want to have that thing. Now, connected with this is another thing that when you want to initiate investigation even after expiry of 8 years, I think there should be due consideration, and that due consideration, probably we could consider that it should be evaluated by a high-powered committee having majority of the independent experts from the market, instead of this being examined or evaluated by the chairman and whole-time member only. Then, in the connection of appointment of adjudicating officer, one very critical provision has been added. Clause 17(2) mandates that a person shall not be appointed as adjudicating officer if he was associated with the inspection or investigation, settlement proceedings, or he has passed the interim order. It's a welcome step. SEBI has been trying internally to segregate all these things, that there should not be a conflict of interest. But I think the ultimate goal should be to establish an independent quasi-judicial body for dealing with all these actions of SEBI. All the enforcement actions should be taken care of by an independent body. Today in SEBI, we have inquiries and adjudication department. They're separate department. Maybe one can consider that on the same lines, that department can form a separate independent body which can look into all these quasi-judicial issues and pass the appropriate orders. In my view, all these quasi-judicial powers should vest with some independent body. SEBI should have the powers to pass only and only the interim orders in the interest of investors and security markets. Now, in the interim order, again, as already mentioned, that the code is providing that the validity of interim order will be 6 months. But again, it is said that this period can be extended by a period not exceeding 2 years. Now the question arises that if originally the validity period of interim order is 6 months, why the extension should be given for another 2 years? Why it shouldn't be restricted to maybe another 6 months at the most? I mean, we have to restrict that. Otherwise, the object which we are trying to achieve is halfway through. And one very critical provision from the drafting angle, I think, is missing. That is the transitory provision. There's no provision that what will happen in case already interim order has outlived 2 years. What will you do with that order? Why all those orders which have exceeded already 6 months, they should be given time at the most for another 6 months after this code comes into power. So there's a need to look from that drafting angle to put that transitory provision so that the existing interim orders do not continue to operate as they are. Then there are penal provisions, and my colleague panelists have already pointed out that the penal provisions have been made very stringent, and penalties in some cases have gone up to 100 crore. Now, in my personal view, these penal provisions require some cleaning up. There's some overlapping. For example, as per clause 94, the maximum penalty for failure to comply with the board's order is rupees 25 crore. But under clause 103, it is 100 crore. Now, as per the existing under section 15HB, the penalty for non-compliance of SEBI order is only 1 crore. We are increasing it to 100 crore. What is the rationale for making it 100 times more? There has to be some justification for that. Then, similarly, we are providing the penalty for non-compliance of the order of adjudicating officer, ombudsperson, or SAT, which again is absurdly very high, that is 100 crore. Now, ombudsman, his jurisdiction basically is to look at the complaint for deficiency in service by the market intermediary or the issuer. I don't see any kind of big issue in the deficiency of service which will require the penalty of 100 crore by the ombudsman. And surprisingly, for the similar kind of violation, adjudicating officer SEBI also has the power, but his power to impose penalty is only up to 10 crore. Why this gap between the penalty powers of the adjudicating officer and ombudsperson on the same powers, on the same matter? So another penal provision, that is, you are imposing the penalty for non-compliance of SEBI order and all that. This kind of issue was looked by SAT in a few matters, where SAT felt that probably this is not the right way to go about, because person, let us say, he is unable to pay this monetary penalty which is levied upon him, and you impose upon him further penalty of 100 crore or so. What object is going to be achieved? Maybe you can consider the punishment by way of sending him to jail and all that. But you can't keep on increasing the monetary penalty. He doesn't have the money. He can't pay the money even in respect to the original order. How will he pay for this penalty for this violating this order? And more importantly, I think some panelists also mentioned the principle of proportionality. In the field of penalties, it's a very important provision that the adjudicating officer or the courts must impose a penalty which is proportionate to the extent of the violation. Now, when we are looking at, as I mentioned already, that for the deficiency in service by the intermediary, you are imposing 100 crore, will it be proportionate? In fact, the factors which are provided under the code is also providing that the adjudicating officer, while imposing this penalty, will consider the proportionality. But the Act as such is not looking at the proportionality. The Act also need to look at the proportionality. When you're putting the amount of penalty, it should be logical and reasonable. Lastly, I would only mention that the jurisdiction of SAT, that earlier was in respect of the orders passed by SEBI under the SEBI Act, SCRA, Depositories Act, and then the orders passed by the PFRDA and ADI. But now in the code, the jurisdiction has been enhanced to cover even the orders passed by the IFSCA, that is International Financial Services Center Authority, ombudsperson, SRO, market investigation institutions like Depository and Clearing Corporation. So the scope and ambit of the jurisdiction of SAT has been enhanced. Thank you very much.
Thank you very much, sir. And your point of relating to penalties and relating to other aspects are truly very important. Now, our next speaker, Mr. Midlesh, because I know we are running short of time. Mr. Midlesh, your point.
Thank you, Pawan, for giving this opportunity. And I am very happy to see all my earlier senior colleagues in SEBI in this panel. I think that virtually all the aspects of the code has already been discussed by my co-panelists in this manner. And I have very little to add on to those issues. But one thing I will like to specifically mention, which was mentioned by the owner sir also, that the missing of the preamble is a very big thing in my view. That preamble should come. If you see the Constitution of India also, the preamble is the biggest thing on which the whole Constitution we read along with that. And the SEBI also, the preamble was a thing which was giving all the impetus to the SEBI activities, whether it is the regulation of the market or the development of the market, what it may be. The focal was coming from the preamble, which was the protection of the interest of investor in the securities market. So somehow I feel that this need to be looked into, that whether this preamble should incorporated in the code also or not. The similarly, the preamble is there in the SCRA also, but I think the SEBI preamble can be considered, and we can recommend that it can be considered for inclusion. The other thing issue which I would like to highlight is about the composition of the board. When we see the composition of the board, the present board consists of 9 members. In that, virtually the one member is coming from the outside, an independent member. We can say he come from the industry or he can come from the academia, whatever it may be. Now, in this changed scenario, we are looking for the 6 members. There may be 6 members which are independent member, maybe from the industry or academia. Whether this decision is based on some study or something, or just out of the head, it has come out that make it 6 members in this regard, and instead of 1 to 6, because it is a 600% increase in the member of that nature. And though it may strengthen the board, but it may have its own implications also, such as the conflict of interest. Because when you're looking for the members of this stature, either we look for the retired people or we go for the industry or whatever, there will be issue of the conflict of interest. And when we say that the members are going to, and I'm finding so many things are being delegated to members, this board also completely, that this will done by the board, this is done by the board. So in that scenario, the conflict issue, dealing with the conflict will be a very, very tough challenge, and this need to look into, because recusal is virtually have had no impact on the decision making process. At times it work in the other side also. That where somebody is recused, and I am interested in this case, then it may have impact on the decision making thinking of the other members also. So this is the one point which I feel that should be taken into account, and we should come out the government should come out very clearly that what is the rationale for increasing the number of independent members by 6 times. So that should be my point. Other points have all been covered by the other members. This one thing I will like to mention about the interim order. This is a welcome step, that 180 days condition that it should be remain, and they should be completed within that period of time. Because open orders, and which is quite detrimental at times, that because generally I have seen that in the order we will debar the person from undertaking the activities in the capital market, and it causes a lot of loss and loss of opportunity also. So these conclusion of these matters should be very, very carefully seen. But it should not become like the IBC code 180 days, which I got lost all meaning. And now no meaning of the 180 days and other things in the IBC code, or 270 days extension. It is going for even the 5 years people are taking for the admission of a case. So once you're putting this kind of condition in the regulation, we should be see that it is implementing the true spirit of the things, and not, it should not just become a letter and any flimsy grounds it can be extended and other things. So these are limited points, because everything has been covered by all my colleagues on the panel, and time is also running away. So I will just conclude my words over here. Thank you. Thank you very much.
Thank you very much, Bidlesh sir, for this. Now, Sharad, your turn, and then last Sundarshan sir. Sharad.
Okay. Good evening, Pawan, and congratulations on your 250th webinar. I mean, I have been attending some of them and I have been missing some of them, but at least you have been doing a great job to the society. So I will just take further the issues raised by my very esteemed colleagues and seniors. First is that the issue of preamble. I mean, that is also close to our heart. And 3 of the issues which were mentioned in that preamble were actually the core and I would say the soul of the Act, SEBI Act, basically, which have now been taken away. And the preamble now says that it is the merger of three acts. So actually, are we supposed to look to those dead acts to find out what is the soul of the new act? So that is a very important issue. And on the preamble, actually, I have always said that this preamble has been taken from the Gita. When I am again quoting Gita here. So Paritranaaya Sadhunam, so protection of investors is the core, and Vinashaya cha Dushkratam. So punishing the offenders and Dharma Sansthapanarthaya Sambhavami Yuge Yuge. So Dharma Sanstapana to establish the rule of law. Actually, that was the core and soul of the SEBI Act, and that sanctity of the preamble should be maintained. Now I come to the investigation timelines. Nagpal Saab mentioned about the 180 days being the being enough time for this. So yes, it can be done in 180 days, and it can be done in 2 months or 3 months also. It can be done in 180 days also. But at the same time, I would say that not all cases can be done in 180 days. And sometimes this becomes a very big bottleneck in completion of investigation. And I have first-hand experience of this timeline. Actually, when I was working in one of the regulatory agencies, so I was given some time to complete the investigation, and then at the concluding days of that investigation timeline, I bumped into another entity, which was very important for that case to be investigated. And I put up a note for investigation of that agency, and that note was rejected, saying that no, you complete the investigation. So, of course, that case came up for discussion after some time, and then it was found that the most important entity has not been investigated. So it was again, referred back to the investigator, and investigation was completed thereafter. So this 180 days cannot be sacrosanct. And I know in government setup or the regulatory setup or in the setup which we have worked here, so people are sometimes hesitant to give the extension, looking at the timelines given in the legislation. So this could be one of the pain point, and which has to be seen very judiciously by all of them, all the concerned. Second is, Parak Saab raised the point of investigation by SFIO and Ministry of Company Affairs. So I would like to mention that at least for the listed company cases, all powers of investigation of corporate fraud should be transferred to SEBI. And the remaining unlisted part should be seen by the Ministry of Company Affairs and SFIO. Because, and if at all required, then SEBI should strengthen its investigation division or corporate finance investigation division, corporate CFID department from a person from outside for a temporary period, if that kind of expertise is required. Of course, we already have in SEBI enough expertise, but still, if it is required, then it can be strengthened for a short time from the outside available resources. But at least all the investigation of the listed entities should be handled by SEBI, and SEBI should be given enough powers to do that. And third is the point of separation of investigation function. I remember in one of the cases of Vishal Tiwari, SEBI Supreme Court constituted an expert committee on separation of functions within SEBI. So investigation division per se should be very independent, as was the case, I think, in Competition Commission of India, where there is a commission side and there is an investigation side. So they are all separate functions and they should not be intermingled. And investigation, as Damodaran sir said in the beginning, that they should have lawyers and accountants. So primarily lawyers and accountants should be part of that team, with of course some technical help from the others. So these are the points which I would like to mention here. Because of the time paucity, you already crossed the time limit. So thank you very much, Pawan.
Thank you very much, sir. I'm sorry that time is really. I expected that you could have speak so many things related to this. Now, as a conclusion and our conclusion comments from Mr. Sundaresan sir, because he has participated, and with him we have done so many programs here and got the markets view, and SEBI has implemented. Over to you, Sundaresan sir.
Good evening to all of you. Am I audible, sir?
Yes, sir. Yes, sir.
First of all, my respectful regards to all the seniors who have spoken before me, and especially to the former chairman of SEBI and the former WTM, Mr. M.S. Sagu, and my colleague, Mr. Sharat Sharma, Mr. Bingilesh, and others. I think they have summarized well. But first of all, I would like to compliment Mr. Pavanji and his team for this 250th seminar, and so meticulously planning it and covering the topics which are of so relevance. I think the entire corporate professional team deserves a big applause and sort of a commendation from all the people for doing it week after week and choosing the topics which are of so much relevance, importance, and beneficial to not only to the, although corporate professional being a SEBI registered intermediary, not catering only to the securities market, but even areas which are beyond the securities market, and inviting panelists from different areas like labor code and sexual harassment matters related and all those things. So I think you have been doing a very good job, and please keep it up, sir, from that perspective. As far as coming to this today's topic, I think it has been very well covered by the earlier speakers. From my side, having been there for more than 3 decades and handled especially the the enforcement angle for more than 1/3 of my career, I would like to highlight certain positive things and the form of concepts which have been introduced. Although the other speakers have pointed out certain challenges in implementing them, and also a possibility of overshooting the timelines and then coming back to the same sort of old wine in the new bottle. But to be fair, first of all, combining all the 3 important regulatory framework for the entire securities market into one is a very good, very positive step. Second, the concept of timelines for investigation, interim order, and such type of things, and also bringing the adjudicating officer or the quasi-judicial officer as a single source for deciding the sort of punishment to be given if the violations are established. It was, in the last 15 years, if you have seen, the same particular case, inquiry has been initiated, sometimes adjudication was initiated, sometimes 11B proceedings were initiated, in some cases parallel proceedings were initiated. So it was all going haywire, and multiple times the courts have also said that why can't SEBI decide, at one particular place, let all the violations come and then see, as Mr. Sagu correctly pointed out, before even the examination of the fact-finding exercise or the taking the reply of the entity, if it goes to adjudication, it determines as if monetary penalty is going to come. So that is more like a, what you call predetermined system. And instead of that, now what has happened is that at one stroke, but it will be very clear for people to know that what are the possible penalties they may be facing. And this is a very good measure from the market perspective. Now, coming to the development point of view, I'm not sure, I joined little bit late, and somebody might have covered also, recognizing the concept of regulatory sandbox. in the securities market, as we grow because of the advancement in technology, so many new things are being introduced, especially in the last 5 to 10 years. Of course, thanks to the adoption of technology, both by the market as well as by the regulator, a lot of things are being automated and the investor protection measures are being introduced. Therefore, recognizing the concept in the statute for a regulatory sandbox is a very good measure, and I'm sure it will help the startup type of things to come forward and then make use of this opportunity to strengthen the existing framework and also come with novel way of improving the technological utilization in the securities market. Another important point which I noticed was that as the main policy of the government over a period of time has been decriminalizing the corporate mistakes or some that type of aspect. So here also what I found was that prosecution can be initiated only for the limited purpose of violations. I think that gives a lot of I'm sure it will give you a lot of comfort to the various corporates. It is not that the corporates are always doing something or the other which needs to be punished with prosecution or something. But now that going forward, it will set a very good trend that these violations, whenever it is committed, will be settled. It is settleable except for few things which are liable for prosecution. So from this perspective, it is very important that decriminalization has been begun. Certain new concepts which were hitherto were not there, like timelines for investigation, other things were not there. But of course, as pointed out by the earlier speakers, all these provisions are excellent on paper, but when it comes to implementation, one has to be very careful. Over a period of time, when SEBI travels, having traveled last 25 years, it has gained an excellent experience from 2002 to 1992 to 2026. In the last more than 25 years, it has gained an excellent experience. Applying those experience, I am sure all these positives will be actually put into practice, and going forward in the next 5 to 10 years, I think this Securities Market Code will have a very significant impact in the development of the securities market and contribute to the overall vision of the government to reach, whatever the plans they have, whether it is a $1 billion economy and the Viksit Bharat and all those expectations we have been given. So I am sure this code will go a long way towards traveling in that journey and overcoming the challenges which will come during the journey to achieve that type of objective of the government as well as the regulatory framework and the ecosystem of the securities market. Once again, I thank Mr. Pawan for giving me this opportunity to speak in this seminar, and I wish all the best in the years to come as well to you. Thank you, sir.
Thank you very much, Sundarshan sir. Thank you. I know the time was short. I'm sorry, Sir Bindleji and Sundarshan sir, but whatever you have spoken from the heart. Now it's a time to close this session. So friend, thank you all my speaker, Luna sir, Sharad, Nagpalji, Sundarshan sir, Bindleji, Damodaran sir, Sau sir, Naginder Parik sir, all. So SEBI alumni meeting I have organized today, and all alumni are here. That is one part. So the point is, every speaker today who has spoken, he is sharing their perspective with clarity and responsibility. That is very, very important, and their experience of doing this. So today's discussion reflects exactly why platforms like this matter, not for conclusion, but for collective thinking. Because whatever we have discussed today, I will compile it and I will put in my book. Sundarshan sir, you have come late. We have released this book, okay, that I will send after including all these things. So the Security Market Code is not just a framework of rule. It is an evolving instrument and demand interpretation, judgment, and institutional balance. That is the part, and everybody is saying some good parts, some part where they have to understand and they have to modify this. Some drafting error which Luna sir has mentioned, it is also welcome point which I have included, noted down, and we will do. So whatever views we have shared are not position or recommendation. You are not giving anything. They are a professional reflection of your experience, of your knowledge, and you have given in good faith. So as per your understanding and contribution to make this ecosystem effective and perfect. As always, this platform of corporate professionals remain committed to learning with discipline, dialogue with integrity, and thinking that strengthen institution over time. Because you have seen, we are not giving long introduction. We are just talking that this is a person they can do, and this is live also on YouTube, so everybody can see this, and this will be continuously updated and uploaded on the system. So whatever you have given, that people can listen and see anytime. So with this, I conclude this session, and I thank everyone that you have, whenever you are appreciating us, it is not appreciation, it is giving more responsibility to do more. And I'm committing to all of you that this dialogue between industry, regulator, and making a bridge and helping professional to understand whatever new happening and whatever the issue where we can helpful to them. My only point is that in our program, we are organizing program which is futuristic also. So sometime I have seen the program which is required today, more people comes. Whenever there is a program where you are proactive, the people think, okay, law aayega jab dekhenge. Okay, but that approach we are following, and we will continuously will do. This book I will send to all of you. I will add all of the new points which we have discussed today. Some of the points are already there, but we'll deal and we will share with you. With this, I thank everyone, all the participants, all the people, those who have come today. We have done just survey of the security market code, send it to the people. Shivam, just tell your primary interaction with security market law is this is the listed company, also unlisted company, more than 40%. This is related to regular core pain point which people have identified. Scope of SEBI power, interim order. So highest, I'm just reading. Scope of SEBI power, they are mentioning market abuse definition, jurisprudence overlay, and then retrospective of changing interpretation of various things. So this is people have said, if in your experience, what most often lead to litigation, the highest number is frequent change in interpretation, and then lack of clear guidance and ambiguous statutory language. These are the point people have mentioned, the highest number where the most litigation is taking place. Shivam, next. Which issue caused the highest business of professional disruption? The number highest is sudden interim action. That is a reflection of all the parts, my panelists, and then unclear compliance expectation. That is another aspect, and the reputational damage. So these are the things. Now, interpretation and arbitrage. Do you believe multiple interpretation of the same provision are being used by different stakeholders? Answer is sometime, yes, very frequently, but sometime majority answer is this. Next. Who benefit the most from such interpretation ambiguity? Nobody. Regulator 30% and industry 20%. But answer is, this is also very interesting. Nobody is getting the advantage. Next. In your view, which is the most prone to interpretational arbitrage? The highest number is 33. That is blue. Market abuse, insider trading, and the disclosure reporting obligation. These are the things. That is this. Intent of legislature versus interpretation. That is also combination. Do you feel that original intent of the legislation often lost due to interpretation by combination of all courts, regulator? So this is another interesting aspects which has come. What would most reduce dispute in your opinion? Detailed guidance note and a clear statutory drafting, and the predictable and consistent enforcement. These are the things which can reduce disputes in the opinion of public. So this was the about Securities Market Code, and this we will send it to all of you. And I'm collecting more. People are saying that we want to give. We will collect and we will pass on to this. Now these are 4 questions we have asked about CP webinar survey during the webinar. The first point was how many webinars of corporation you have attended so far. So more than 10 webinar. Majority people are the highest number. More next. How was attending corporate professional webinar impacted your professional knowledge? Highly impactful, moderately impactful, slightly impactful, not impactful. Shivam, last 2, you must talk to them and identify what are the issues and how to improve this. These are the point where people are saying security law highest because that is a listed company, a regulatory update and company law. These are the points where people are saying. Now next is that which feature would you make webinar more engaging you? Presentation by speaker, this is highest, live question answer and post webinar resources which we share everyone about the presentation. Last point. So this was the overall things. So with this, we are closing this session today. Thank you very much again to all of you. And our journey of knowledge sharing will continue on 6th February. We will meet again with the new topic, with the new speakers and with the new our existing delegates. Thank you very much.
Thank you. Thank you.
Thank you.
Thank you.